says here that way, sorry. Okay, Mr. Chair, we're in public session.
Great, thank you. Good morning, everyone. If I haven't spoken to you since our last meeting, Happy New Year. And this will be the first session, public meeting, committee meeting, commission meeting of the new year. Welcome everybody back, and let's begin. Let's call the meeting order. Just to confirm we have a quorum present.
Confirmed.
Okay. Item in the public agenda is the approval of the minutes of the public session from December 14th, 2021. Correction. A motion to approve.
Is that Weissman?
Commissioner Weissman.
Commissioner Weissman.
Second, Fisher.
Fisher.
All in favor? Aye.
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 3, 4, 5, 6, 7, 8,
Aye.
9, 10, 11, 12, 13. It's unanimous, sir.
Thank you. All right, moving on to the report from staff, operations update.
Yes, thank you, Mr. Chair, and Happy New Year to everyone. The operations report is under tab B in the agenda book. Again, another busy month, and I should say a busy year. Our statistics compare favorably with prior year's statistics. I'm happy to answer any questions there may be about the operations report. I will add that on the second page under FDS filings, in the notices of delinquencies issued, the note indicates that 15 had been filed as of November 16th with 2 outstanding. Those 2 outstandings have now been taken care of. Those filings have taken place. So all 17 notices of delinquency have now been satisfied, which is very good news. If there are no questions about the operations report, I'm going to turn this over to Steve Boland, who will give the third quarter financial report. Steve?
Thank you. Good morning, everyone. We'll go over the third quarter financial report, October through December 2021. For personal services, we spent just over $1,071,000 for the quarter, for a year-to-date balance of just over $3,566,000, or 78% of our cash personal service budget. For non-personal services for the quarter, we spent almost $159,000 for a year-to-date total of almost $461,000, or 44% of our cash balance. For total spending for the quarter of just over $1,230,000, and a year-to-date total of $4,027,000, which equates to almost 72% of our budget. There's a little minor imbalance between personal service and non-personal service. As I said, we spent 78% of our personal service and only 44% of our non-personal. I'll be talking, we'll try to correct that imbalance in the remaining quarter. Does anyone have any questions?
Commissioner Fisher has raised his hand.
Yes.
Okay, thank you. This is
Fisher.
Commissioner Fisher. I wanted to ask about the part of the budget that we use to pay for outside legal advice. I know that we hired one firm to represent us with respect to a subpoena from the Attorney General's office on the referral we made over to them. I know that we also authorized management to hire a firm to represent us in an investigation of our own activities, I guess.
Yes.
Where are we with the spending on those items, and where are we against the budget?
That would be in non-personal services under contractual services. And with the addition of those proposed charges for this year, we will be spending pretty much all of our budget. We're going to have to manage, try to reduce or eliminate as much non-personal service charges as we can, and we've already made that decision. So eliminate discretionary spending, but that's where they are.
So at the last meeting, I believe there was conversation around hiring outside counsel to assist our investigators in the numerous investigations that we have going on. Do we have funding for that, or are we going to be constrained by the budget?
We don't. I'm not aware of that conversation. Maybe Monica would know how much that would be. In terms of.
Yeah,
I'm sorry, Monica.
Yeah, let me say this.
Sure.
All right, Monica, you go ahead.
Well, I think, Commissioner Fisher, to what you're referring is we had discussions about that we have a lot of resource-heavy investigations going on, and as we mentioned, we are in the process of trying to hire another investigative counsel. There was some discussion about retaining, contracting with a lawyer to assist. We're first working on hiring a new lawyer on staff, and we'll see from there. Both of those processes would take money and time. If we hire on staff, it comes out of our PS budget, and we've allocated for that. If we hire a contractor, it would be under our NPS budget, and we would have to have further discussions about that. But as Director of Administration Steve Boland has said, we are predicting that we are going to cap out on our non-personal service finances for this year, based on our already, our already planned outside counsel services.
So when we cap out, will we be constrained from doing things that we need to do or that the commission wants done?
We've never had a problem before. We've never been in this position before, but, the end of the fiscal year is only a few months away. So, I think these things are going to take some time either way in terms of getting additional help. And so some of this might fall into next year's budget.
Okay, thank you.
Are there any other questions? Thank you very much.
All right, Chair, next on the agenda, we have the confidentiality and records access proposal.
Mr. Chairman.
One second. Commissioner Levine.
Thank you very much, Mr. Chairman. As a follow-up to the line of questioning posed by Commissioner Fisher, has Hogan Lovells actually been engaged to conduct the internal investigation of the book approval?
The contract is in front of OSC right now.
I'm sorry. Just one moment. I'm not sure about the way that Commissioner Levine phrased that question about the scope of the retention, but to answer the question with respect to the retention of the Hogan firm, the contract's been executed and been submitted to the Comptroller's office for approval. That was done yesterday, and so we are waiting for that approval, and then we will move forward, and Hogan is aware of the status, and the Comptroller's office is aware of the priority, and we'll move forward expeditiously as soon as it's approved.
Now, do I understand, Madam General Counsel, that the Commission voted to conduct an internal inquiry of the approval of Governor Cuomo's publishing endeavor in October? We haven't started the inquiry.
The discussion about the retention took place in the executive session, and a statement was made in the public session by the chair. And the reason I'm raising this is I don't think the language that you're using matches the language that was reported in the public session by the chair. And the discussion that you may be referring to took place in a closed session where I was not present. So, I want to be careful about what we say in the public session with respect to that retention. It is described in the contract. It's described in the paperwork that's been submitted to the Comptroller's office. And it is consistent with the way that the chair described it and any public session discussions that were made regarding it.
Well, I'll put the question then to Judge Burr. Yes, thank you very much.
But 1 second. Commissioner Levine, I think we're going to have an extensive conversation about this in executive session as to the status of things and what are the next steps. And if any concerns, we can express them in executive session. Do you have anything else, Commissioner Levine?
Well, I'll defer the substantive discussion of the executive session, Mr. Chairman, but I will say, because it's in the public domain, the commission voted to conduct this inquiry, I believe, unless someone on staff wants to correct me, 5 months ago, and it hasn't begun yet. To me,
it's a public record when that's this resolution, so I think everybody knows when it was done.
All right, Mr. Chair, we'll be prepared to address this in whatever detail Commissioner Levine or others wish in executive session. It is on the agenda.
Thank you very much, Judge.
To answer any questions at that time.
Thank you, Commissioner. So as to the proposed regulation amendments on confidentiality with records and records access.
Yes.
Presenting that on that from staff.
Yes, I'd like to just introduce the subject. As the Commission is aware, committee was formed to address confidentiality and disclosure matters in February of 2020. There have been a series of implementations to accomplish that, including our monthly operations reports, the new public statement policy, and the amended records access regulations. We now have these proposals. I'm going to turn it over to Monica, our General Counsel, to discuss these in greater detail. I do want to thank her, Deputy General Counsel Martin Levine, and also thank Megan Matullo for helping to pull these together so quickly and so effectively. Really a major accomplishment here in what they've done in so short a time. But with that, let me turn it over to Monica.
I just want to make sure it's noted that this was discussed at the October meeting as well, and that we committed it to the Confidentiality Committee, which began discussing the matter. And I'm glad to see that these regulations and the proposed amendments have been turned around so quickly. So I thank Monica, Martin, and everyone on staff that was involved with this. Go ahead.
Thank you. Monica?
Sure. As the chair mentioned, this was discussed at the end of last year, the direction to develop regulations consistent with the work of the Confidentiality Committee, which was formed in February of 2020. So for the last 2 years, that committee has been working with staff and has made recommendations, and changes have been implemented for the work of that committee, including the new monthly operations report, which we've been doing for nearly a year now, the public statement policy relating to investigative matters. The Commission amended its records access regulations to make a lot of information more publicly available. And so today there are several of the remaining proposals of the committee are incorporated into 2 documents for the Commission's consideration. These are aimed to continue to increase transparency and respond to the criticism that the agency is too secretive about its work and its operations. The proposed amended regulations for adjudicatory proceedings and appeals are at tab C, and the proposed resolution is at tab D, and these are also posted on our website. As discussed at the December meeting, these regulations can be adopted on an emergency basis, and the Commission can also begin a revised rulemaking so they can move forward on parallel tracks. The emergency regulations would become effective upon submission for publication in the state register, and they'd be in effect for 90 days, and then the Commission can subsequently renew them for 60 days. Publication of the notice of revised rulemaking would initiate a public comment period. If those are submitted today, if the Commission approves them and we submit them today, they'd be published on February 9th. The comment period would end on April 10th, and then staff could bring them back to the Commission for consideration at the April 26th meeting. With this timing, if the regs are adopted, the emergency regs would have to be renewed and extended at the March meeting so that there isn't any break in their effectiveness. The resolution, if the commission adopts it, would become effective immediately. The key points and changes in the regulations are in sections 941.3 and 941.16. The changes, for the most part, and there are additional changes, but the biggest changes are they provide for more notice to the complainant and respondent of Jacob action on matters. For example, there'll be notice if the agency sends a 15-day letter, if it votes on whether or not to commence an investigation, or if a matter is closed by the agency for any reason. The commission may continue to authorize communications with other parties of interest at its discretion. The regulations provide that the commission will maintain a list on its website of investigative matters that have been closed by case number, redacted as needed to protect confidential information. The regulations codify the commission's recent motions and resolutions that allow the commission to publicly disclose confidential investigative information when it's in the public interest to do so, and to make general public statements about the status of certain investigative matters that are already in the public sphere. The resolution provides that the commission may disclose information about otherwise confidential guidance if the requester makes public misstatements about the nature of such guidance. The regulations and the resolution provide for more disclosure in Jacob's annual report, including a listing by case number of each investigative matter and its status, again, redacted as necessary to protect confidential information, as well as information about agency compliance with ethics training requirements and late fees imposed on lobbying entities to put us in line with what the New York City Clerk's Office does with respect to its late fees for lobbying. And I just want to bring your attention, in case you missed it, Commissioner Yates proposed an additional small amendment today, and it's in section 941.2D as in dog. And so that is on, sorry, I'm not sure what page that's on, but it's issued, everyone should have received an email, and it is
page 2.
Thank you. The change, it's on page 2? Sure, it's to the definition of commission. And it is to add to the definition of commission, it shall, this is already in there, shall mean the members of the Joint Commission on Public Ethics, except where the text or context indicates that the commission's executive director or staff, or both, and it used to read may act on behalf of the commission, and Commissioner Yates is suggesting we switch it to are authorized to act on behalf of the commission. So that's in addition to the version that's posted on the website and that was circulated to the commissioners, incorporating all the other changes.
Mr. Chair, I'd like to speak to that.
Hello, this is Jose Nunez. Do you hear me?
Yes.
Okay.
Commissioner Braun asked if he may speak to the regs.
Yes, go ahead. Yes, Commissioner Braun. I had to switch over.
I have another comment, but let me start with what Ms. Sam just emphasized, which
I'm sorry, there's some feedback, so if everyone who is not speaking could mute, please.
Thank you. I have a number of comments, but I'll start with what you just spoke of. Firstly, let me thank you and the rest of the staff for all the hard work you did and the Committee on Confidentiality members did, which I was not on that committee. However, I spent a lot of time yesterday, hours going through not just the book of things that we're taking up today, but related matters, and including this. And 10 o'clock last night, I got an email from our executive director as to this, and then it went to everybody as far as I saw, and then Commissioner Yates made a proposal. I don't see that as a small proposal. I see that this is a major clarification. I've been on the commission now for a year, so I don't know, other than what I've heard, I don't know what's gone on in the past, but there's been some back and forth and disagreement about who's the commission. And as I said in the email, which I'm going to make it easier, I'll read it now. It's 100% clear to me as a matter of interpretation of the laws set forth by the legislature in their enactment of the commission, that the commission are the members are us, the commissioners. With all due respect to our executive director and staff now and over the years, who I've observed doing a very effective and hardworking job, the responsibility rests with the commission, us commissioners, to make determinations, unless we delegate to staff. And so, just to make that clear, and that's why I think that Commissioner Yates' amendment is important. Well, Executive Law Section 94, Sub 1, established the commission, which says it consists of 14 members. Those are us, the commissioners. Section 2 sets forth how the members, meaning us commissioners, are appointed. Section 9A states that the commission shall appoint an executive director, and 9B says the commission shall appoint other necessary staff. If the commission is appointing executive director, if the commission is appointing other staff, it is obvious from the beginning part of the statute that the commission is the members and does not include ever include the executive director as staff, except to the extent that we, the commissioners, delegate powers by way of a vote to the executive director and to the staff, which has been done in the past numerous times. The commission is not the commission itself is not a living being. It exists through us, the commissioners, and we act, and the executive director and the staff act through delegation of powers by the commission. Therefore, it's clear to me, 100% clear to me, that the commission means us commissioners, and the executive director and staff have delegated powers which have been delegated to them in the past and probably will be delegated in the future. Therefore, Commissioner Yates' amendment should be included in the regulations. I'll save my other comments for later.
So, sure. Just to clarify, Commissioner Braun, most of the paragraph is already in the draft that's in front of you, and the only change I think that Commissioner Yates is making to the draft that's in front of you is just changing the word may act to are authorized to act. And so I wasn't dismissing the importance of how we define commission. I just meant that it's just a small change to the definition that's in that we already put into the regs that was suggested by commissioners over the weekend.
So, Monica, was Commissioner Yates' revisions incorporated?
No, we just received this additional change this morning. So okay. The version that you have right now looks almost identical to what is in Commissioner Yates' email, except it says it shall mean the members of the Joint Commission, except where the text or context indicates the Commission's executive director or staff or both, may act on behalf of the Commission. That's how it reads in the version in front of you. And Commissioner Yates is suggesting we change may to are authorized to. So if you look at the version you have on page 2, the definition of commission, this is a version that was emailed last night, which was incorporating changes we received from the commission after we circulated the original draft. This definition of commission was already included. It's in the one that's in front of you, and it's in the one that's posted. The change is that Commissioner Yates is proposing is changing the word may to are authorized to.
All right, Commissioner Yates, do you want to speak on the amendment?
I just have a point of information, and that is the draft we received from the executive director last night around 10 o'clock the same as the one that's posted on the website and in our books? Because Monica, I just want to know what we're voting on.
No, let me just clarify. The one from last night reflects the revisions that had been discussed in various emails among the commissioners, exclusive, Commissioner Yates, of the one that you provided, the edit you provided this morning. The version in the book was the original version of the proposal that was previously circulated.
The version that is posted, just to be clear, the version that's posted on the website is the same version that was submitted circulated to the commission last night, except the one that's posted is a clean version. So that is the version that's before you, the one that was submitted last night, which incorporates commissioners' edits, except for your email, and that is the one that is publicly available right now.
Thank you.
Mr. Chair?
Go ahead, Commissioner Gershman.
I have to say that, first of all, I agree with Commissioner Braun with respect to the definition. I also was very surprised to read this language in the draft I received last night. There was a flurry of email activity. I must confess that I did not give total attention to every email that flew by. And so had I seen it, I would have, along the lines of the argument made by Commissioner Braun, objected to the change because in the version of the book that I had, the commission was defined as the 14 commissioners and not as the executive director or the staff, but made clear that the commission has the ability to delegate power to the commission staff, executive director and staff to act on our behalf. I just am, I don't know that the changes that are reflected in the version that we got last night could fairly be said to be the consensus of this commission when they weren't discussed except in the email strain that, to be honest, was at times onerous.
So does the commissioner have a suggestion as to how to proceed forward? Should we table it and have further discussion? Or are we going to make the amendments at this point and then vote?
Well, my suggestion would be to remove the language referring to except where the text or context indicates that the commission's executive director or staff or both may act on behalf of the commission, and to go back to the version that was in the book, but accepting Commissioner Yates's suggestion with respect to the with respect to the language may or is authorized to.
Any other comment?
And if you need me to so move, I will so move.
Hold off on the motion. I just want to see if anyone else has any comment on it.
Mr. Chair, may I make one observation? Just for clarification. The definition here that we're discussing relates only to the adjudicatory regulations of the Commission. There are definitions elsewhere in the regulations of Commission, and the definition is intended to be specific to the functions and activities that are regulated by this part of the regulations. So it's not intended by any means to be a global definition of commission, but it's rather a practical definition here simply to clarify that in certain instances, the intention when the reference is to commission, as with serving papers or making filings or other ministerial acts, it doesn't require action by all 14 members of the commission. And that's the only purpose of the definition in this part. It's to clarify the language in the various regulations that are set out throughout the adjudicatory regulations. Bear in mind, we've only modified some of them, and there had been a point raised about the propriety or scope of the definition we had, and so we adjusted it as a practical matter to make it clear how the adjudicatory regulations were intended to work. So if you look through the entire body of the Commission's regulations, you'll see commission is defined in several of the parts.
If I could just add, very quickly, my comment relates to the commission completely, it was not just in relation to this regulation, any powers of the commission, for us, the commissioners, except were delegated to the staff, whether it's in this regulation or anywhere else. At this point, Mr. Chair, with your permission, I would yield the floor to Commissioner Yates, who you may not see, has had his hand up for a long time.
No, I do not see. No, I do not. Go ahead, Commissioner Yates. Go ahead. Sorry about that, Commissioner Yates. Sorry about that, Commissioner Yates.
First of all, I agree with Commissioner Gersman and Commissioner Braun. I think we're all trying to do the same thing. My amendment was only, let's go back in history. You had an earlier draft that didn't make the change regarding the definition of commission. Then last night around 10, we got one that changed it. So then I wrinkled that with my amendment. But the whole purpose was, as Commissioner Braun just said, and I think Commissioner Gersman has been saying, is that at the outset, for the entirety of all our regulations, it should be clear, it should be clear that when we say the commission, we mean the commission or the executive director or staff when so authorized. And that means for every function. Now, we have several delegation resolutions out there already, so we delegate a lot of functions to the staff and the executive director. The statute is crystal clear. The statute says that any action of the commission requires a majority vote of the commission, but that the commission may delegate certain authority to the staff, but only if it's specifically included in a resolution, if it's itemized. That's what the statute says. So all I'm saying, and all Commissioner Gersman is saying, and all Commissioner Braun is saying, is the same thing, and that is let's follow the law. And that is throughout all our regulations, and it should be global. When we say commission, we mean, as the statute does, a vote of the members, unless there's been a specific delegation to staff.
Okay, so just to be clear, the language that's in our books right now in regards to the definition can be accepted with the only change, and how would you change it exactly? Just to be clear so we know what we're voting on.
Well, I'm okay with what I think Commissioner Gersman and Commissioner Braun suggested, and that is don't change the existing language which says that it shall mean the joint commission, that was under existing law, which may delegate authority.
Right.
That's true. That was good. But then I thank the executive director. He pointed out to us the flaw, and that is that this is particularized to one segment of our authority, and that if we really want to do what the statute says, what we ought to do is go back to the global definition and say that all throughout our regulations, whenever we say commission, we mean the commissioner and the commission by vote, unless there's been an authorized delegation by resolution.
All right, thank you. Commissioner Gersman, do you have a motion?
Well, my motion for these purposes, for the regulations in front of us, is to go back to the language of this particular regulation that is in our books, not the one that's on the website, not the one that was given to us at 10 o'clock last night, but the one that's in the books with the amendment that was proposed by Commissioner Yates to change the word may to is authorized to.
Okay. And are you comfortable with that, Commissioner Yates?
Yes.
All right. So I imagine Commissioner Gersman, you're making the motion. Commissioner Yates, you're seconding the motion.
Yes.
And I think we can vote on that.
I'm sorry. I'm not sure I follow what the Commissioner Gersman's language. How do you want to incorporate Commissioner Yates' change into the definition that's in the version in your book? So the version in the book says the Joint Commission on Public Ethics, Commission, or JCO shall mean New York State Joint Commission on Public Ethics, established pursuant to Executive Law 94, which may delegate the authority to act as provided in these rules and regulations to the executive director. I think you don't need to change it to accomplish all of your goals. But if you wanted to change it, we'd have to, which you'd have to flip it around, which to include the executive director, or staff. It doesn't quite work. I'm trying to figure it out on the fly. I don't know if someone can do it.
So, go ahead,
If I may read the regulation as I believe my motion puts it before the commission, it would be the Joint Commission on Public Ethics Commission, or JCOP, shall mean New York State Joint Commission on Public Ethics, established pursuant to Executive Law Section 94, which is authorized to delegate the authority to act as provided in these rules and regulations to its executive director.
Okay. Any other questions or concerns? Commissioner Braun?
Yeah, could you read that again, Commissioner Gerstmann? I thought you said JCOP equals JCOP unless, it should read JCOP equals the members unless. Maybe I misheard it, but I thought I heard it differently.
The members isn't currently in there, and I just, but Commissioner Gerstmann, my concern is there's a separate delegation which delegates authority to staff to effectuate a lot of what's in these regulations, but it's not spelled out in these regulations. So if you change it the way that you're suggesting, we need to make additional changes throughout the regs. I think it's just it's complicating this, and maybe there's a better way to accomplish your goals.
Perhaps is authorized to delegate the authority to act as provided in the executive law.
Instead of rules and regulations.
Instead of in these rules and regulations.
Yeah, I'm not sure that works either. Which is authorized to delegate authority to the executive director as provided in the executive law?
As permitted in the executive law.
To its executive director.
Yes.
Permitted.
Okay, so this is what I have, and then Commissioner Braun, your question is, right now, it does not refer to the members. The Joint Commission on Public Ethics, Commission or JCOP shall mean New York State Joint Commission on Public Ethics, established pursuant to Executive Law 94, which is authorized to delegate authority to the executive director as permitted in the executive law.
Okay, so you just switched it over. Okay.
Yes, I would propose amending that to say in the second part, the members, rather than the commission, is the commission.
So, Commissioner Braun, you're suggesting the Joint Commission on Public Ethics, Commission or JCOP shall mean the members of the New York State Joint Commission on Public Ethics, established pursuant to Executive Law 94, which is authorized to delegate authority to the ED as permitted in the executive law.
I would accept Commissioner Braun's amendment to my amendment.
Any questions, any concerns, Commissioner Yates?
I think this is a friendly amendment. I don't want to do too much wordsmithing around and around here, but if you were to make it the Joint Commission on Public Ethics Commission, or JCOP, shall mean the members of the New York State Joint Commission on Public Ethics, established pursuant to Executive Law 94, unless the commission has delegated the authority to act as provided in these rules and regulations to the executive director.
So Commissioner Yates, that's my concern again, is that the delegation isn't in these regs necessarily. The delegation is outside of these regs. So we would have to go back through these regs separately from the meeting today and make sure that everything that's been delegated is incorporated into the regs. Why don't you just, it would be, except you could do unless authority has been delegated to the executive director as permitted in the executive law.
Yeah. That's okay.
Okay. So I'm going to try again, but correct me if I get this wrong. The Joint Commission on Public Ethics, Commission or JCOP shall mean the members of the New York State Joint Commission on Public Ethics established pursuant to Executive Law, Section 94, unless authority has been delegated to the executive director as permitted in the executive law.
I think there's a problem with accepting that language because the definition of JCOP is still JCOP is still the members. It's acknowledging the authority to delegate, but the definition of JCOP still is the members. So I don't think that necessarily moves us forward, Commissioner Yates, in terms of the issue that.
Fine, I withdraw it and I'll go along with your language.
Thank you.
Okay. Good. So, Monica, are you clear on the language now? We're reverting back to Commissioner Kurtzman's revision.
I'm not clear, Mr. Chair. Could someone read it from the top?
I'm going to try and let okay, go ahead.
The Joint Commission on Public Ethics Commission, or JCOP, shall mean the members of the New York State Joint Commission on Public Ethics established pursuant to Executive Law, Section 94, which is authorized to delegate the authority to act as provided in the Executive Law to its Executive Director.
All right, we're all clear?
Okay, so if the commission is going to make this change, then in the version that is on the website and in the version that was emailed around last night, we added a definition of JCOPE, G-O-C-P-E, to mean the agency. It only appears in one section, which we'll delete now. So we're going to take that out. We don't need that definition now. But I'm going to recommend, and Judge or Martin, if you think this isn't the way to go, I'm going to recommend we make an additional change in 941.16. Give me 1 second. Where are those published? 941.16D, page 20. Subparagraph 2 and 3, instead of saying pending before JCOPE or no longer pending before JCOPE, I think it should just say pending before the agency or no longer pending before the agency. So we're not distinguishing between when something is with staff or with the commissioners when a matter is pending. It's just, it's pending before the agency in its entirety. And so that I would recommend we make that change to go along with your change to the definition.
Any issues with any questions?
Yes.
Go ahead, Commissioner Yates.
Monica, I'm not sure I see the need for that because if someone makes an application to staff, if we take, for example, we've delegated to staff the ability to delete something from a filing, from an FDS, fine. If it's pending in front of staff, it still technically is pending before the commission, even though we've delegated to staff the ability to do that. So I don't know why we have to say agency there. I mean, everything that staff is doing is pending before the agency. You're not acting, you're not acting on your own outside the agency. or outside the commission.
Right. I just don't want to imply in any way what status the investigation is at. And I think if you say pending before the commission, it suggests it is being presented for a vote in some way to the 14 commissioners, as opposed to it's just, the agency has received a complaint or it's pending with staff. It's not a huge issue. I just don't want it. Our goal here is transparency, and I don't want to create more confusion by suggesting that pending before the commission means that it's at a different stage than it is. If everyone's understanding is that means it's with the agency and not necessarily at a point where it's been presented to the commissioners for a vote, then I'm fine. But that was the goal here, was these statements are supposed to be generic and general and not suggesting sort of where in a process it is. And so I don't want to create confusion there.
I think pending means a lot more than pending for a vote, and I agree with Commissioner Yates. I don't think you need to change the language.
Okay, all right.
Yeah, so do I. Jacob is the commission. The commission consists of the commissioners. So I think it's fine as is.
Fine.
Are we addressing other issues as well with the draft at this time, Mr. Chair?
We will, yes, we are, because I want to take a vote on it as amended. So any other issues or suggested amendments should be brought forward.
Are we voting on my amendment and then going on to the next issue?
I think usually you would.
Yeah.
Sorry, usually you would go through all your changes and vote as a whole unless there's a disagreement on an issue, but.
I'm thinking that's right. I think we go through all the amendments and we can discuss them and then vote for the entire thing. So any other amendments, Commissioner Kirkman?
I do have two other issues, Mr. Chair. I don't know if you want me to address them now.
Go ahead.
One of them is on page 20 in subsection D. I don't see, and I don't know if this is the right place for it, but I do recall that there are instances where the matter is referred back to the originating agency, and I don't see that as one of the things that can be publicly disclosed, and I think it should be included in the list of what can be publicly disclosed under subsection D. I didn't see it addressed anywhere else. I don't know, maybe I missed it, but it seems to me that when we make a referral back to the originating agency, we should be able to disclose that.
Is that anywhere in the proposal, Monica? We don't hear you, Monica.
Yeah, these reflect the previously adopted notifications that we were authorized to make. So those were that level of specificity, giving the reason for the matter being closed, was not part of that original group of disclosures staff was authorized to make. So this was simply an incorporation of that.
Right. This is for when matters are sort of already in the public sphere and meet this criteria that are in the preceding paragraph. Staff can make these very general statements about the status of a matter, but without any specific detail. This was a policy that the Commission adopted this summer, and so we were just incorporating it. If what you're thinking about is that you want us to provide notice to a complainant or a respondent if the matter is, if staff has gotten authorization to communicate with an agency, I'm not sure if that's what you're thinking about, or you're thinking about guidance letters. We could do that in 941.3. Notice of additional steps. Right now, I think the Commission has complete discretion to do that whenever it chooses. We didn't cover that specifically in the notices that we've created. we have, if notice of a matter is, if we've sent a 15-day letter, notice if the commission has voted on a matter, and notice if the matter has been closed for any reason, which could accomplish some of that, but we haven't included in here automatic notices of intermediary steps.
So if I understand you correctly, when we refer it back to the originating agency, that's considered a closure?
In some cases, I mean, often we're sending it to them. In many cases, we're sending it back to, I don't even know if I'd say sending it back, but we're sending it to the agency to do an initial inquiry and then report back to us on what they found, and then we make a determination. Ultimately, if after that we close it, or if we did close it, as you suggested, when we sent it to the agency, if in our view it was closed, then the notice of closure would apply.
Yeah, and that's why I raised it, because it's my understanding that sometimes the referral back to the originating agency is not a closure, and it seems
right. So then the matter is still so the matter is still pending, and we're waiting for more information, and then that matter, as far as we're concerned, is an active matter on our pending list until we hear back from the agency or something's developed with the agency.
So if
at any time it gets to a point where,
if you think it more appropriately belongs somewhere else, I'm fine with that. I just think that our disclosure should be able to be to include when we refer it back to the originating agency.
Well, again, just for clarification purposes. Yeah, I was just saying that these are instances where the commission has delegated to staff. In certain instances, essentially where there's been public disclosure and taking into account various factors, the authority, and if you will, the discretion to acknowledge very limited facts, make these very limited statements. So we might say a matter is no longer pending, or that it's been closed, but not give the reason. That at least thus far has not been part of that authorization. And as Monica said, of course, as these regulations, these amendments are structured, the commission would always have the discretion to provide the additional information. But again,
Commissioner Jacob raising his hand? I don't hear you, Commissioner Jacob. We don't hear you, Commissioner Jacob.
Maybe muted.
Hello?
Yes,
you hear me?
Now we hear you, yes.
What I wanted to point out is that C and D, and I think Executive Director has done that or begun to do it. C is the commission shall consider. These are commission disclosures. D was what we did this past summer, in which staff was authorized to make these disclosures. Now, if Commissioner Gerstmann's amendment is made, it enlarges the discretion of the staff, because if what we authorized staff to do this summer did not include what Commissioner Gerstmann is now suggesting. Of course, it falls within what we can do as a commission. But the purpose of D this summer was to authorize staff to go forward with these disclosures. So if we're comfortable on enlarging staff's discretion when a complaint is referred back without coming to us to make that kind of disclosure, that's fine. But it does not mean that we as a commission cannot do it if staff doesn't do it. We either want to enlarge staff's discretion in this regard, or we don't. That has nothing to do with C. It is D that we're focusing on. So whatever you want to suggest, Commissioner Gerstmann, I'm okay either way. I can leave it as is. If need be, we can do it as a commission. Staff comes to us, tells us it's been referred back, and they disclose something. But if you want to leave it in put it in D, add it to D, we're enlarging staff's discretion.
And I appreciate.
The steps issue right in front of you, but it depends on which steps you're coming up. Not the steps next to the elevator, the other steps.
I appreciate the history, Commissioner Jacob. I was not a member of the commission during the summer, so I was not party to that discussion. Had I been, I would have made the suggestion then, and I didn't realize this is a mere codification of what was done over the summer. I think under those circumstances, I will withdraw that suggestion and leave it perhaps for a later date for a broader discussion of what additional items we may want to authorize staff to disclose.
Thank you.
Did you have an additional
I just have
suggestion?
one other, and that is on page 19, subsection C9. I'm not sure if action or inaction also includes the subject or the details of the commission's determination. And I think where there's been inaccurate or misleading statements as to what the commission has determined, for example, in a request for outside activity, whether or not subsection 9 covers that. If everyone else is satisfied that it does, then fine. But I at least had the question as to whether or not it would include that.
So just to clarify, Commissioner Gerthman, the issue I think you're addressing is actually covered in the proposed resolution behind tab D, which is that the commission, if the commission adopts this resolution, it's just recognizing the commission's authority based on the motion at the last meeting that it can correct any misleading or inaccurate or incomplete public disclosure that is made by a requester of guidance. So we put that in the resolution because these regulations are about and this portion of the regulations is really about the investigative process and not guidance or outside activities necessarily. Obviously, if there was an outside activity issue in connection with an investigation that was going on, that would be covered within 9. But I think between the resolution and the way 9 is already worded, I think what you're getting at would be covered.
Okay.
But I just wanted to draw your attention to that. And I should also just remind everyone that if the commission adopts this and moves forward, again, you have the option to do this on an emergency basis and begin a revised rulemaking. We will get the possibility of public comment that will suggest additional changes, and the commission will have another opportunity to consider these regulations and any changes it wants to make at most likely the April meeting of the commission.
Thank you.
Any other concerns or questions?
That satisfies all of my other issues, Mr. Chair.
Commissioner Braun?
Yeah, as I said, I have several. Page 4, it talks about, the commission receives a sworn statement. It doesn't refer to referral, though. Shouldn't that be in there?
I'm sorry, what page?
Page 4,
What page is it referring to?
section 941.3 sub A on page 4 speaks of various possibilities that could lead to us taking action. It refers to a sworn complaint. It refers to filing a statement that shows a possible violation of the laws or us acting on our own initiative. It doesn't include a referral. So I would suggest it should include a referral in that provision.
We can add that. This is the language is really drawn from 9413A, which the referral language shows up later in the section when it's talking about presenting a scope to the commission. But we could add it here. If the commission receives a sworn complaint or referral alleging.
Or referral, right.
All right, so we'll incorporate that change.
And if you move to the next page, page 5, sub B, it does include referral, It does include sworn complaint. It does include us acting on our own initiative, but it leaves out the last portion of the fourth matter in 941.3A, which is where there's a possible violation evidenced in a statement. So I think it should include that in that subdivision 1 of subdivision B. I don't know when the date would start, the date of filing?
So I just want to be clear, this is the statutory language, and this is about the 60 days
Right.
from which the commission has to vote is really targeted to only when a sworn complaint or referral is received or when the commission begins something on its own initiative. So if a violation was revealed in a filing and we sent a 15-day letter, then we would have to present to the commission within 60 days. But we don't have that tight 60-day timeline otherwise because someone failed to include something in a statement. And I don't think you would want to impose that on yourselves because we often don't discover shortcomings in statements for long after 60 days from when that statement is received. So this language here very much conforms to the statute and the process that we've been following, and it really is just relating to the 60-day timetable there. And I don't think you want to change when that 60-day timetable kicks in. The real import of this is just that we're going to provide notice of when the commission is going to vote, which is new and hasn't been part of our procedures for the past several years. And so that's really what this is about. But I don't know that you want to change that language, which it really just goes to when that 60-day vote requirement kicks in.
Well, Monica, you're speaking exactly to what I started to say, which is I don't know when the 60 days would commit in relation to a filing that shows the possibility of some impropriety. So I think you've spoken to it, but except let me just still raise the question. You did talk about when would it commence? It's not the statutory 60 days, but when would it? Is there any deadline imposed?
Yes, when we send a 15-day letter. If we determine that there's if we have reason to believe there might be a knowing and a willful violation in connection with the statement, then we send a 15-day letter, and then you have 60 days. So it's incorporated within that. But the way this is structured, we have time to develop that, make that determination. We also have a process in an FDS violation where we send a fail to file letter and a notice of delinquency. So there's proceeding steps. So it's covered. It's just if we initiate an investigation, and I don't think you want to change the trigger otherwise, but it's definitely covered. It's the same thing. We could get a tip or a complaint that come in. They routinely do. That doesn't start our 60-day date. It just, once we determine there's enough to suggest there's a violation of law, we send a 15-day letter. That starts the 60-day count.
That makes
60-day clock.
Perfect sense. Next, I only have a couple more. This also to me is very important. This is page 18 and 19, pages 18 and 19, which relates to confidentiality, another issue that the commission and staff have batted back and forth in discussion, apparently way before I and some of the newer commissions came onto the commission. Again, interpreting the law, to me it's clear, although it could have been put in a context that would have made it more clear. Executive Order 9-A sub B says, in a separate sentence, says any, underlining and me adding emphasis, any confidential communication to any person or entity outside the commission related to the matters before the commission may occur only as authorized by the commission. It might have been better if that had been placed in its own subparagraph, but it doesn't say it's limited only to what's in that subparagraph B. So to me, we, the commission, can vote to waive any confidentiality per this provision if we so voted. The suggestion I would make to this paragraph, and this regulation, the amendments, for which I'm thankful that it's here, and and that the confidentiality committee and staff put this together. But the only thing I would change is on the top of the second page of our book, it says, until a determination of such disclosures in the public interest. That's somewhat limiting. So I would just change the word upon to the phrase, including but not limited to when. So it would read, a commissioner or staff, including but not limited to when the determination of such disclosures in the public interest is set forth below. So that is what I would propose as an amendment. Otherwise, I'm fine with this part of it. I do have I have a comment on the next page, though, kind of for discussion. Should I make the comment, Mr. Chair?
Hold on. Let's hear from General Counsel in regards to that specific revision.
Sure. However you want to do it.
Go ahead, Monica.
I mean, this is really a commission decision. We implemented, we incorporated this based on the Commissioner Jacobs' motion at the December meeting. And the reference there was that it would be, after, in the discussion, which is reflected in the minutes, is that it would be subject to a determination that's in the public interest. So it's really the commission's decision. The language that you are proposing, Commissioner Braun, would mean it doesn't have to be in the public interest, and there's no real standard then for when the commission would make such disclosure, because including but not limited to would include when it's not necessarily in the public interest. But that's really the commission's decision. Staff agrees with Commissioner Jacobs' suggestion that it should be subject to a public interest determination, but again, I'll leave that to you.
Commissioner Jacobs?
Yes, I would suggest that we leave it as I had proposed it, because there's got to be a standard that we've got to focus on, and that's what C and the 16 factors are about. The 16 factors help guide us as to what is in the public interest. And so you've got a page that follows that line at the top, which guides us on the public interest standard, which is a good cause standard. It's public interest. It's found in many statutes. But if you delete the standard, then what do we follow? So I think we leave it as it is. If you agree, I would oppose no standard.
Well, let me say two things. Number one is I don't think it's no standard. We would set the standard by voting at the commission. This would have to be by vote of the commission. There is another hand to this, which I thought of when I read this last night and wanted to raise this for discussion, which is the standards that you just spoke of in subdivision C do have a catch-all. That's paragraph 16. It says, any other factor the commission deems relevant to determining whether the release of such information is in or would otherwise serve the public interest. So I'm now, in a sense, maybe speaking against what I first raised, but I do recognize that it has been articulated that it is open, that we can decide.
There's a catch.
In essence, anything would be in the public interest that we vote if we rely upon paragraph 16.
Yes, so exactly.
I can live with it. I just prefer to having a broader language as I initially proposed. But if the rest of the commissioners don't see that as necessary, I can live with it because of paragraph 16, subparagraph 16.
Thank you.
Okay, so what would be your next recommendation?
Okay, here's something. Okay, paragraph 11 at the top of page 20. I'm uncomfortable with this paragraph. Whether the disclosure could impact any election for public office, consider the temporal proximity of the proposed disclosure to the election and the nature of the information. The discomfort is what would be the motivation for the disclosure or the non-disclosure. I totally understand what's being said here, and maybe why, but this could be used in different directions, and that's why I'm uncomfortable with it. Different directions politically. This commission should never be acting politically. I have not in any of my decisions that I've made, and I would think and hope that other commissions same. But we should not be acting for political reasons. We should be acting in the public interest, and acting for political reasons may or may not be in the public interest. It may be in the interest of one candidate, positively or against the interest of a candidate. That's why I'm uncomfortable with this position.
So your recommendation is to remove it?
Well, before I make first I want to hear other commissions.
I think, Judge Braun, you make an excellent point. And based upon my experience, we should never be guided.
Never.
I've been in other agencies, never be guided by political events or political campaigns. I agree with you. We should be guided by the public interest. Period.
Anyone else?
Well, then I will move that it be deleted.
Well, Monica. Well, hold on. Well, Monica, do you have any advice in regards to that, or comment on that?
Let me say this. I don't know if Monica maybe is muted.
Oh, sorry. Yeah, I was just going to explain, Judge, that this criteria was developed, not just this one, all of the criteria developed after reviewing the policies of several different federal and state agencies, prosecutorial agencies, investigative agencies, and others relating to when they make disclosures, if they make disclosures. So I don't think it matters if you take one out, and as Commissioners Braun and Jacob already recognized, the last factor gives the Commission a lot of flexibility to consider other information when pertinent.
Okay.
But sorry, Judge, you would wanted to add something to that.
No, I was simply going to reference that this had previously been one of the criteria that the Confidentiality and Records Access Committee had articulated. But I agree with you. We do have effectively the catch-all in there. Or there's something.
All right.
I don't know if that's carrying over, but
go ahead. I'm sorry.
But as Monica said, I think it works because we do have the catch-all. So,
Commissioner Yates?
Well,
Somebody is rustling a lot of papers, and that's causing interference. So again, if you're not speaking and you can mute, thank you.
I think we all share the same concern, and I just want to make sure that we're clear about how it's being resolved. We've seen over the years that people will lodge a complaint during an election cycle. Many times there may not be much merit to the complaint, but the mere fact that the campaigner can go out and say, hey, Jacob is considering this ethics violation against X, can be an important factor in an election. And I think we all share the same concern that we don't want to be used that way. Now, if you're telling me that by taking that language out, we can still make a judgment by a majority vote that as to whether or not something should or shouldn't be disclosed because there's an unfair representation that's out there, then I'm okay. But I just want to make sure that we still have that option to take into fact the real world, and that is that someone's profiting off a misrepresentation, and we're the instrument, and we don't want that to happen.
Monica? I think the last paragraph allows us for that. Is that correct?
I think the last paragraph allows the Commission flexibility to consider any factors that aren't necessarily identified in the list. But I think that Judge Yates identified the exact reason that this was included. I mean, over the course of the last decade, we have definitely received politically targeted complaints, and then there have been announcements about those complaints, and many times those complaints aren't even within our jurisdiction. And so this was meant to give the commission flexibility to consider this issue, but I don't know that removing it impacts that flexibility. It was really to identify what the criteria would be that the commission would consider with some specificity.
All right, Commissioner Braun, do you still want to move forward to eliminate it?
Yes.
Okay. Any other revisions or
I just have one minor
ahead.
grammatical.
Go ahead.
Page 21, subparagraph E, sub 1, sub I. It says listing blah blah blah. Second sentence, alleged a possible violation within its jurisdiction, just change its to the commissioner's jurisdiction.
Yes, it refers to the commission.
So I'm proposing to say that.
That's an easy change.
Yep.
Right.
Okay, good.
As I said,
Anything else?
that's it for me.
Any other commissioner has any recommendations? Hearing no other suggestions or recommendations, we'll vote on the amendments as moved by Commissioner Gersman and Commissioner Braun. So including those amendments, we'll take a vote on approving the proposed amendments to the regulation. All in favor?
Chair,
Go ahead.
I'm sorry, just to clarify, there's two different approaches here. You can, and I don't know if you want to just start with the revised rulemaking, then and move forward on that, and then you could have a separate motion on whether to move forward on an emergency basis. But I just wanted to clarify that. Okay.
Yeah, that's what I'd rather do. So on the revised rulemaking, do we accept the, was there anybody else?
Chair, we also need a motion and second.
Okay, so a motion in favor of that.
I second that.
All
Who
right,
is that that seconded?
I see Commissioner Braun and Jacob.
Okay, Commissioner Braun and Jacob. All in favor?
One, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. I see 11 in favor.
Commissioner DePiero? Is she still on? All right, no.
Commissioner DePiero, you might be muted.
I'm in favor.
Well.
That's 12 in
Okay,
favor.
very good.
Okay, so that's 12, and then you just need to call for a vote.
Any opposed? Seeing none
I'm in
opposed?
favor.
Correct. Thank you, Commissioner
We hear you,
DePiero.
Commissioner DePiero.
Monica,
Thank
do you hear me?
Yes.
Yes.
We do hear you, Commissioner DePiero. So
Okay.
I don't see anyone opposed. Did we miss someone?
Abstentions.
Chair, call for abstentions.
Any abstentions?
Commissioner Fisher.
Oh, I see.
Commissioner Fisher, I got you. Okay. All right. I believe that passes.
Yes, sir.
And now we'll take up the matter of whether to implementation on an emergency basis. Is there any discussion? Commissioner Weitzman?
Chair, I don't have any discussion, but if there is none, I move it.
Okay. Do I have a second? Second by Commissioner Henricks. All in favor?
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 in favor.
Commissioner, any abstentions? Any oppositions?
I have
One opposed?
One opposed.
Commissioner DePiero, are you, can you just
I'm in favor.
indicate?
In favor.
Okay, that's 12 in favor and one abstention.
Opposed?
No, it's
opposed. One opposed.
it's 12-1.
Commissioner Fisher, please
Oh.
vote.
Opposed?
Closed.
Okay, sorry about that.
All right.
Okay, and then that brings us to, so we will proceed on that. Chair will send you a certification shortly that we need you to sign, and we're going to try and get this submitted today, which means that the regulations will be effective today for 90 days while the revised rulemaking is ongoing. And that
Now we move
brings
to the
us
resolution.
to the resolution.
Okay. Any recommended changes to the resolution or discussion? Commissioner Gersman? You're muted, Commissioner Gersman.
I have one issue that may require a small amendment, and it has to do with the first results clause. It says that the commission, halfway down, it says the commission may release information relating to the guidance request, including but not limited to an redacted version of any guidance provided. I'm not sure that also includes an unredacted version of the application for guidance or the request for guidance. And I think it's just as important that we have the ability to release the unredacted request.
General Counsel, what do you say about that? As far as
I mean,
unredacted version?
I think that the request is incorporated within this because it may release information relating to the guidance request, including but not limited to. But if the commission wants to specify it here, that it doesn't change anything.
I just am more comfortable that way because the we've singled out the unredacted nature of the guidance, but we haven't at the same time included the unredacted nature of the request. And I think just in an abundance of caution that we should include language that says may release information relating to the guidance request, including but not limited to an unredacted version of the request for guidance and of any guidance provided.
All right, so it'll reflect that amendment. Any other changes or suggestions, commissioners?
The first resolve.
Go ahead, Commissioner Jacob.
The first, Monica, if I may, the first resolve, I believe that is the law as of now. Isn't that the law? Do we need that resolution?
So,
what do we accomplish with the resolution?
The practice of the agency and the law provides that only redacted versions of guidance can be made public by the commission. I think what you may be referring to is, the motion that you made at the last meeting, which is that the commission can make information available, as we just went over in the regs, if there's public interest determination. The regs, though, do not apply to the guidance. So this would just be sort of codifying this position, which is new and different and is unprecedented. The agency hasn't done it before. So it puts everyone on notice. And as, I mentioned at the beginning, this is really just part of the committee and the commission's work to increase transparency. So it just is putting it out there clearly that the commission intends to do this going forward, and then there'll be no questions about it.
Okay, because it seems to me once information is public, it's public. And if inaccurate information or whatever information is released and the commission acts to correct an inaccurate disclosure by someone who sought guidance, goes without saying. We can do that. That is the law. So if you want to just put it in a resolution so as to put the people we regulate on notice that is what we do, and I don't know if there's anywhere in here that we ought to say that is the law, because I don't think we're breaking any new ground with this resolution.
All right.
I mean, I understand that, but this is not something the commission's ever done before. So it is sort of putting people on notice. It is putting an end to debates that have been taking place for years about whether the commission has the authority to do this, and it doesn't restrict or limit you in any way. So it just sort of affirms this transparency that the commission wants to move forward with. I think that in the whereas clauses, we talk about the authority.
Yeah, I understand.
Which has been reflected and traditionally exercised, that only these things are only made public. Well, the requests have never been made public, and the opinions have only been made public previously in redacted form. So it's really up to the commission. It doesn't limit you. It's part of the package.
Okay, but again, we're talking about disclosures that have been made before the commission even acts by the recipient of the guidance, who preempts our disclosures by making his own or her own. So as long as it's, I don't know that we even need a notice provision. Section 16 and the plain meaning of what's public and what isn't states it all. But I have no problem if you want to leave it that way.
Commissioner Yates?
Yes, the last whereas clause troubles me. Until we did the revised resolution on delegation of authority, there wasn't anything in the law for the last few years that was clear one way or the other about the authority to give an informal opinion by staff and whether or not it was cloaked in confidentiality. The statute makes no reference to it. There's nothing in the statute that even creates this thing called an informal guidance. So what we did last year was we went ahead and said, okay, look, there's been a practice of informal guidance by staff, and even though it's not in the statute and even though we didn't delegate it previously, we will delegate it going forward in certain instances. And so what we said at that point was that those opinions would be, that what we were going to do was revise them only prospectively. We weren't going to go back to what had been done in the past. We never said anything about confidentiality one way or the other. We did say in the resolution, we made it clear that informal guidance going forward would be treated similar to formal guidance. And that is that we could go ahead and disclose it only in redacted form. My problem here is this goes beyond all that, but the whereas clause here seems to lump together the informal guidance, staff advice, with formal guidance. Formal guidance is cloaked under the statute with confidentiality, but if you read this, one would say, well, old informal guidance we're now also cloaking with confidentiality, which we've never done. We never voted on that one way or the other. And let's be clear. I mean, we're talking about if last year or the year before, staff gave informal advice to someone, we did agree that we can go back and revisit it as long as there was full disclosure and an honest application. We said that. We weren't going to otherwise go back and revisit staff. And we did say going forward that we would only release them if redacted. But we never said to ourselves, old informal advice can't be disclosed. It's confidential. And that's what the way I read this whereas clause. This seems to be saying that any decision staff made last year or the year before that, that we're binding ourselves and saying, oh yeah, that's just as confidential as formal decisions. And we're agreeing that those also are cloaked in confidentiality. We've never done that. We never really resolved that one way or the other. There's an open question. I know Commissioner Levine has raised this from time to time about whether an old informal advice, since it wasn't sanctioned by the statute clearly, could be by a majority vote of the commission disclosed. And I don't think we should, that whereas clause bothers me the way it's phrased.
Monica?
If I may, Commissioner, I don't think this is the delegation of the commission, in 2101, the paragraph 2, the last sentence is the commission reserves the right to publish prospective informal letter opinions in redacted form. So I'm not trying to change anything here. I was just trying to encompass what was in that delegation. This is the prospective informal letter opinions could be published in redacted form. I believe that is what the commission agreed to. I'm looking at the old delegation in front of me, but we don't need this.
We never bound ourselves. I would amend that whereas clause just to say, whereas formal guidance issued under Executive Law 94/16 is confidential, but may be published in redacted form, the commission as well has reserved the right to publish. I wouldn't even talk about it. We've never resolved the question of whether or not informal advice retroactively could be disclosed. It's never been resolved or voted upon by us.
Right. That's why this says prospective. I mean, this is I'm quoting the language from the delegation that you and Commissioner Kushner negotiated and presented and was approved by the commission.
But
I just read it.
You're making it look like informal advice is confidential, except for prospective with redacted form. Yeah, that's why I don't even know why you need that whole section there. We've never said that informal advice in the past is confidential. The statute didn't say it, and we've never done it by resolution. And now
So you just want to delete the and in resolution 2101 from there to the end of the semi.
Beginning is it says guidance.
I would just say guidance issued under Executive Law 94/16 is confidential, but may be published in redacted form, period. Because that's the law.
Right, that's what I just said. Okay, so just delete the reference to resolution 2101 and what follows.
Okay.
Okay.
All right. Any other recommended changes? Seeing no other recommended changes, do I have a vote to adopt the revised version of the resolution? Motion to move.
So moved.
That was Commissioner DePero?
Commissioner Brown?
Commissioner Brown. Gotcha. Second?
Second.
Commissioner Braun? All in favor?
One, two, three, 4, 5, 6, 7, 8, 9, 10, 11. I see 11 hands.
Any opposed?
Commissioner DePiro?
I'm here.
Wait, Commissioner DePiro?
Yes, I'm
Are you
here.
in favor?
Yes, in favor.
Commissioner Jacob, your hand went up late. I don't know what your position.
Well, I'm in favor.
Okay.
12, 13.
Any opposed? I see none opposed. Any abstentions? Do we have a vote from Commissioner Fisher?
I voted yes.
He voted in favor. It appears to be unanimous.
Okay, very good.
Yes, I got it.
Thank you. All right. Moving down the agenda, new and other business. For new and other business, I'm going to ask the General Counsel to provide us an update on the disposement resolution that we passed late last year, and where is the status of that?
We received a letter from counsel for the governor, which was made public, raising issues with respect to both resolutions passed by the commission late in the year. And also, I have some legal issues to discuss with the commission relating to the resolutions in the executive session.
All right, we'll discuss further in the executive session as to any legal issues. Any other? Other business?
Could I just get a statement, a more specific statement with respect to where things stand? So, Monica, we passed Resolution 2104 on December 14th, correct?
Yep.
Yeah, and that had a order that required disgorgement of the proceeds of the book within 30 days. So that puts us at January 13th, which date has passed. Have we received any communications from the governor or the governor's representative with respect to that order?
What we have received is a January 12th letter from his counsel.
Okay. Requiring...
Which was on within the 30-day deadline.
Okay. And the letter that we received from the Attorney General's office, that was December 16th, and we responded to that letter on December 29th. Has there been any further written communication from the Attorney General's office?
I've had additional communications with the Attorney General's office relating to legal issues, and I'd like to discuss those with the Commission in executive session.
Understood, but any further written communications from the Attorney General's office?
Just along with my communications were both in writing and by email with General Counsel to the Attorney General's office.
Okay.
Any other other business?
Mr. Chairman.
Commissioner Levine.
Thank you very much. I have a motion. I move that the staff be directed to issue an informational subpoena to the Executive Chamber with regard to Executive Order 202.7 that was promulgated by former Governor Cuomo and subsequently revoked by the legislature. Specifically, the subpoena should elicit a list of so-called volunteers who are within the ambit of the executive order, whether any particular exemptions or other arrangements were made with regard to these volunteers with respect to perceived conflicts of interest, the employment status of volunteers, whether in fact they were true volunteers or were being paid by their employers other than the state of New York, and any other pertinent information with regard to conflicts of interest that were presented during the course of the response to the pandemic by the involvement of so-called volunteers.
Is there a second to that motion?
I second it.
Second by Commissioner Jacob. Is there discussion, comment? Commissioner Fisher.
I have a question. Do we have an estimate of how many volunteers? As I understand it, medical professionals, nurses, doctors, people that came from other places in the state or even out of state would fall under the ambit, to use Commissioner Levine's word, of this resolution. How many volunteers are we talking about?
We don't have that number.
Okay. All right. I believe it's in the thousands of people that volunteered, and asking someone to collect employment information on all these folks who generously donated their time, including medical professionals, seems absurd to me.
Thank you, Commissioner Fisher. Monica, what's the protocol or history on informational subpoenas?
So this is a matter that, the Commission, this particular request is something that the Commission has considered and discussed many times over the past year. And it's been voted on. Of course, the composition of the Commission has changed, I think, since the last time this was voted on. And there have been questions that were raised previously relating to our authority to issue this subpoena. Just for the newer commissioners, we initially made a request for some information relating to whether or not the chamber had a process that it was following with respect to the previous administration chamber, how to process it was following with respect to this executive order. And the response was, just what is your authority for making this request? And since then, there's multiple discussions among the commission about whether or not the subpoena authority in 9417C covers the type of informational subpoena that Commissioner Levine is suggesting. And the commission hasn't resolved that question. I've done some research on that issue, which, again, I would prefer to discuss in executive session as to whether or not the commission has the authority to issue an informational subpoena. But that's sort of where this is. And then the other discussions among the commissioners was what would we be doing with this information? What would be the plan for processing this information? What kind of resources are we going to devote to this? And since this is being discussed in the public session, is the information that we receive going to be confidential, or we're asking for this to be public disclosure? So those were questions that the commission previously discussed when this motion was made in the past.
And Executive Director Berlin, what's the potential status in our staffing? Can we resource such a activity?
We've discussed this in the past, and because the potential volume of information is the likely volume is enormous. We don't presently, given the volume of the matters we're processing and handling within our budget, and with limited staffing, even with the goal of increasing that staffing, that's targeted to pending matters that we will discuss in greater detail in executive session. I've suggested before, if there could be a more targeted way than a broad, and I'd characterize it as an informational subpoena, but something more targeted aimed at a specific allegation or a particular concern, where we could focus and narrow the request. Conceivably we could put resources on it, but such a broad request would put an impossible strain, at least on our current staff.
Commissioner Braun?
Well, Commissioner Fisher raises a valid concern of having such a large class, including people who wonderfully volunteered their time to assist us in our great time of need during the edge of the pandemic. And Executive Director Berlin also indicates that this could be more targeted, possibly, and it would make it less unwieldy. Although whatever staff has to do, we and they will have to find a way to accommodate if this passes. So I pose a question to Commissioner Levine: is that can you limit the scope of your motion to include the concern that Commissioner Levine raised and the Executive Director Berlin spoke of in a somewhat different way?
Commissioner Levine?
Can you hear me, Mr. Chairman?
Yes, I can.
Thank you very much. This discussion is edifying to the extent that it underscores the point we don't know what transpired. This information has been kept top secret. For what reason? It's been kept secret. It was kept secret by the Cuomo administration, and will now test whether it's going to be kept secret by the new supposed reform administration of Governor Hochul. We don't know who the volunteers were. We don't know the number. The staff has posited a presumption that the data will be unwielded. We have no idea. Let the executive chamber inform us. Then we can proceed accordingly. I'm not amending the motion.
I thought the original motion included more information than just numbers. Why not limit it in the first instance to numbers? Therefore, whatever the number of volunteers of healthcare personnel, whether from within our state or who are so good as to come from without the state, once we have that number, we can presumably remove that as a category to ask for further information.
Judge, you've persuaded me. So I will now change my mind within 30 seconds. Thank you for having me change my mind. I'll amend the motion. I move that staff be directed to issue an informational subpoena to the executive chamber with respect to eliciting with regard to Executive Order 202.7, now revoked by the legislature. 1, the number of volunteers who are within the ambit of the executive order. 2, the names of any volunteers who presented a conflict of interest circumstance. 3, a discussion or exploration of how those conflicts were resolved. Thank you, Judge Braun.
Any other comment? Judge Braun, Commissioner Braun, you're muted.
I'll return the courtesy of seconding your motion.
Okay.
Thank you.
All right. All in favor, raise your hand.
1, 2, 3, 4, 5, 6, 7 in favor.
All opposed?
1, 2, 3, 4 opposed.
I'm in favor.
8, 4, and I'm missing 1. Commissioner Jacob, which way were you voting? I assume.
He seconded.
Yeah, I know. I just need to record it.
Martin, I don't have this vote, so just make sure you have who voted how.
Can I get those opposed again just one more time for recording?
I'm sorry, is this opposed?
Yes, that is what it is.
Opposed.
Yates, Nieves, Hinrichs, Fisher. And 8 in favor.
And all in favor, can you raise your hands again?
5, 6, 7, 8, and then 9. 9, 4.
All right, Martin, again, I didn't get it, so if you've got it, then we're good.
I have it.
Okay.
All right. Any other new or other business?
Yes, Mr. Chairman.
Commissioner Levine?
Thank you very much for your indulgence, Mr. Chairman. I move that staff be directed to divulge to the Commission in executive session all inquiries made during the Cuomo administration by the Office of Inspector General or the Executive Chamber to review the financial disclosure statement of any filer. Thank you, Mr. Chairman.
Monica, was this previously addressed?
Yes, I mean, the Commission, again, this is something the Commission has discussed multiple times, but the way Commissioner Lyon just framed it is slightly different. So you're saying of any filer. So the Commission previously addressed this going forward with respect to filers by, in the Records Access regs, and effective January of 2022, any filer can request to see a log of any requests that were made for their financial disclosure statement. Separate from that, the Commission now receives a log of any subpoenas that have been issued to the Commission, which would include subpoenas for financial disclosure statements. But the Commission has not addressed whether all subpoenas going back for the last 10 years should and requests for the last 10 years for any FDS should be shared with the commission. So I think that's sort of a new question. I mean, I should mention in the past, you know, I guess the issue was unique to seeing commissioners, requests for commissioners' FDSs, and there were concerns that commissioners shouldn't have access to information that other filers couldn't get, but this is different, so I don't have anything further on it.
If I could just, by way of clarification, ask Commissioner Levine, would this extend to instances in which there was a request that the request be kept in confidence by the commission because of some investigative interest that the requesting entity had, for example, the Inspector General's office?
You're muted.
Yes, thank you very much. That's precisely the object of the motion.
So the instances in which there was a request to maintain confidentiality, just so we understand. Thank you.
Whether there's a request or not, all inquiries by the Executive Chamber or the Office of Inspector General to review an FDS made during the Cuomo administration.
All right, thank you.
I would just add whatever the commission decides to do on this. Walt may be able to answer part of this with respect to records access requests, but with respect to subpoenas, we will not be able to answer this today in executive session. It will take us some time to prepare it because we don't keep a list in an easy, accessible way like the logs that we started creating. So we'll have to put that together.
Oh, Mr. Chairman, if I may. I can't hear you, Mr. Chairman. Can you hear me?
Go ahead, Commissioner Levine.
Yeah, the report by the staff the next meeting is fine.
Thank you, Commissioner Levine. Okay. Commissioner Yates.
I just want to know what happens when we get the information. As I understand the motion, in executive session, we commissioners will see what requests have been made in the past. At that point, is it confidential? And in other words, whatever one or more commissioners who get that information then are not permitted to go out and talk about it publicly or to other parties? Or is it the intent of the motion that it will be disclosed to us commissioners in executive session, and then we're free to disclose it, or by majority vote can disclose it? I want to know the consequence after it's turned over to us, because, and I'll just say it briefly, I think obviously the commissioners all have a right to see anything that's been submitted to the commission. But I'm not sure the commissioners want to agree to then turn around and disclose things that have been disclosed to us in confidence.
May I, Mr. Chairman?
Go ahead, Commissioner Levine.
Yes, thank you, Judge Yates. The object of the exercise is to ascertain one aspect of the operation of the Inspector General during the Cuomo administration and the fellow traveling involvement of the executive chamber itself in exertions to intimidate or to cover up, depending on the object of inquiry. Therefore, it is my intent that the information be discussed in that context and that the information remain confidential unless the commission votes otherwise.
Commissioner Fisher?
Chair, I have a concern about it because if any of the commissioners were the subject of one of these requests, that commissioner or commissioners would thereby learn about it, and anyone else subject to a FDS request by these entities would not find it out. So here again, we would be providing preferential access to this information to our commissioners and not to anyone else, which doesn't seem right.
Mr. Chairman.
Commissioner Levine.
There is what I will characterize in an informal sense a rule of necessity. In order to discharge our responsibility to address wrongdoing as alleged by the executive chamber or the Inspector General, we need this information. The staff has the information. It should be turned over to us.
So you've had a long-standing request to find out whether you were the subject of this, and this will accomplish that goal. And I just have a concern about that others that might have a concern equally as valid to yours would not receive this information because they don't have membership in this commission.
Thank you for your sentiment. I'm not withdrawing the motion.
All right. I don't believe there's a second to the motion.
I'll second that.
Okay, Commissioner Jacob is seconded. At this time, we'll take a vote. All in favor of the motion, say aye.
1, 2, 3, 4, 5, 6, 7, 8. I see 8 hands. Commissioner DePiero, do you wish to vote in favor?
Yes.
Okay, that's 9.
All opposed, please raise your hand.
I see Fisher, Nieves. Looks like McCarthy.
Any?
We're missing someone.
Any abstention?
Commissioner Brown. Walt, does that cover us? I believe so. 9-3-1.
All right. All right, so now I ask for a motion to enter into executive session pursuant to Executive Law 9419B. Do I have a motion?
So move, Fisher.
Fisher moving, second. Second by Braun, Commissioner Braun. All in favor, please raise your hand.
Okay. Appears unanimous. No. Commissioner Levine. Okay. And Commissioner DePiero.
Yes.
Okay, it's unanimous.
All right, very good.
Who's in the lower left?
We're back in public session.
Thank you.
Chair, would you like me to report?
Yes, General Counsel Stan, please report out.
Sure. The commission, during the executive session, the commission discussed matters related to litigation and personnel. The commission approved informal guidance pursuant to Executive Law 9416. The commission commenced one substantial basis investigation. The commission authorized steps in several investigative matters and closed 5 matters and discussed several other investigative matters. That's it.
And Chair, if I could just add one thing. On January 13th, we held our annual training for ethics officers across a panoply of agencies on filing financial disclosure statements. We had over 115 ethics officers in attendance, which is our highest number ever, and our staff received very positive feedback on that. So I just wanted to report that. Thank you.
Excellent. Thank you. We need a motion to close the meeting?
So moved.
So moved.
Commissioner Jacob.
Jacob, and I see...
Commissioner Jacob and Weissman. All in favor, please raise your hand.
6, 7,
We'll
8.
take Commissioner Brown and DePiros.
DePiero, yes.
Brown, yes.
Motion carries.
All right. Thank you, everyone. Have a good night.
Thank you, and Happy New Year, everyone.